be seated. Good morning. How's everybody today? This is the first argument for the Southern panel. Mega Manufacturing versus District Court, case number 62396. Mr. Jaffe, ready to proceed?
Yes, ma'am. Thank you very much, Justice.
How are you today?
Oh, well, Justice. How are you?
Good.
Good morning, Justice Augustine, Justice Douglas, Justice Cherry, Stephen Jaffe, and I'm from Hull, Jaffe & Clayton on behalf of the petitioners. And with the court's permission, I would like to reserve 2 minutes for my rebuttal. Thank you. May I proceed, sir?
Yes, of course, please.
Justices, we here request that the court now reinforce Nevada's stated policy of affording protection to the opinions and conclusions of those which critically analyze when an injury occurred and who adopt changes to make Nevada safer. Number two, we ask that the court protect the sanctity of a client's communications with their lawyers, especially when that client expects to be sued. Your Honor, we ask relief in a twofold process. Number one, to protect the document at issue through either the attorney-client and or the work product privilege, and to protect the opinions by adopting the self-critical analysis privilege.
Counsel, at the outset,
yes, sir.
As you've raised your points, if you'd also reference how that relates to NRCP 26B3.
With respect to
obtaining discovery of documents and tangible things otherwise discoverable under and so on.
Well, it's our position, sir, that the document as addressed by the Discovery Commissioner was discoverable to the extent that there were facts contained in there observed by my clients. We did not make an issue of that above. It's the opinions that we seek protection of, because those opinions are exactly what should be deemed privilege, and that's what we ask the court to now protect, sir.
Why would you not tell the people not to put their opinions in a written document? Why would you not tell your people not to put their opinions in there, just to put the facts and the opinions?
Well,
instead of the opinions.
It's difficult for me at this point, obviously, because this is a document that was created prior to my involvement with respect to this particular client. They had hired their corporate counsel at that time for that purpose, or consulted them. So I can't speak as to why that attorney did or did not. As a general matter, though, I believe that if a client is going to reach a conclusion to share with their attorney for various purposes in obtaining legal advice, that a client should be free in sharing that information with their attorney, and it should then be protected. In addition, if it's going to be put in a document so that others within the company will have the benefit of seeing it for the purposes of making their product safer for the future, and in this case Nevada safer, of course, then those people should have the benefit of those opinions, particularly when those involved are a chief engineer and the person who's involved in the design of the product. So I think certainly there is benefit in doing so. I think it's and I would submit that it should be protected as privilege, and also protected given the fact that the overriding purpose is to make everything safer. I hope I addressed your points.
Yes.
Thank you. With respect to this particular document, I need to point out that there are certain facts that really are not in dispute. Number one, that on January 5, 2010, my client was placed on notice of an incident, that my chief engineer contacted the company's private attorney, that the attorney provided legal advice expressing concern for litigation, creating an expectation in my client's individuals' minds that a lawsuit was potentially coming. And I believe that that's a key distinction, because this is not something where I believe that we need to be looking backwards in hindsight, but I think we have to view the client's perspective in real time as to what were their expectations at that moment. Now, there is an issue with respect to a comment having been made by the distributor's representative to my clients on January 7th. My clients insist that they were told that the day before an attorney was there, and it's not disputed that an attorney for the plaintiff was there the day before, but that comment was made to the extent that someone will be sued. That comment confirmed that expectation in my client's individuals' minds. The individuals reported twice over the next few days to their attorney, both by telephone communication, and then wrote the report, reasonably believing that the lawsuit would ensue, which was confirmed by the next day when counsel actually did place them on notice of representation. So, if anything, the expectations in their minds at the time that they were conducting this inspection were confirmed shortly thereafter, and they at that point went so far as to put their insurer on notice.
Mr. Jeff,
Yes, sir.
do you have a copy of the report there in front of you?
I don't have it in front of me, sir.
Okay. There's a couple of entries in the report. One indicates that Jimmy and Neil flew out on January 6, 2009. I assume that's a typo.
That's a typo, sir,
Yeah.
2010.
And then the next paragraph represents that Michael Haight, injury attorney for Hennessy Haight, was present. Is there any dispute about that?
Yes, sir, I believe there is. I believe that that was a mistake, or I think it was simply a matter of wording, taking two engineering people and applying precision to their words when the indication was, I think, that Mr. Haight had been there the day before they arrived. And my interpretation is that when they indicated in that document that Michael Haight had been there, that it was not at the exact same time they were, but the day before. And I don't believe that that particular fact is in dispute.
Okay, so counsel for the plaintiff was present on January 5th.
I believe it was the 6th.
Or 6th.
5th or 6th, I don't know the precise date. But it was the 5th or the 6th, and my clients arrived on the 7th.
Well, that's what I'm trying to clarify. Jimmy and Neil were unable to find a flight out until the next morning, January 6th.
Right.
Because at the customer, 3 people arrived to investigate what happened on Wednesday, January 6th. One of them was Michael Haight. So I'm trying to, what you're saying though is that entry is supposed to reflect the fact that counsel for the plaintiff was present at the site the day before Jimmy and Neil were present.
That is my understanding, sir.
Okay.
It's my understanding that they had intended to try and get out on the 5th, but there was a snowstorm, and they could not get out of Chicago timely, and that's why they did not get out until sometime on the 6th and could not get to the facility, AMF, until the 7th.
Is there anything in the record that indicates that the engineers communicated their knowledge of the presence of plaintiff's counsel to in-house counsel for your client?
Let me also clarify, sir, he's not in-house counsel, he's private counsel.
Private counsel.
That he specifically communicated that fact, no, I don't recall seeing that in the record, sir. I believe it was simply that it was reported to them by a distributor's representative that he had been there the day before or within a day or so and commented that someone will be sued.
And what are the facts that you point to that you would argue causes us to reverse the finding of the district court that the report was not prepared at the request of counsel?
I believe so.
And in anticipation of litigation, what would be the facts in the record that you would point to that would cause the panel to reverse the district court's findings on that point, on those 2 points?
With respect to the work product privilege, sir, it is our belief that the record does reflect that counsel advised the representatives, Neil and Jimmy, to go to Nevada to inspect the machine for fear that litigation would ensue. That's number one. Number two, that I believe the district judge overlooked in large part the affidavits that were submitted on behalf of my client and focused instead of the representations made by Mr. Metz as well as Neil and Somerville and Jimmy Berry on the single comment of someone will be sued. That was the one issue that he constantly referenced without referencing the other points. And we believe that the district judge overlooked that point, and that was a significant point causing the Discovery Commissioner to protect the document at the inception.
In your papers to the district court, did you propose any redaction of the report, or were you seeking to have the entirety of the report declared work product?
We were asking the entire document to be declared work product, and so I also have to point out that we later amended our privilege log to include the attorney-client privilege, because at the time that we first prepared our privilege log, we had the document, we saw that it was work product, but we did not, because it referenced discussions with counsel, but we did not see that it was actually sent to counsel per se. So once we found that fact out, we amended our privilege log to include the attorney-client privilege, which was raised below with the Discovery Commissioner. We did try to ask that the entire document be preserved. When the Discovery Commissioner ruled that the fact section should be disclosed, we did not make an issue of that above.
I wanted to understand your argument to this panel now. If I understood your argument as you began, you're seeking primarily the protection of opinions expressed in the report as opposed to factual recitations. Is that correct?
Well, we believe that the factual recitation should also be protected. We raised that below. Our primary concern is the opinion, sir. And for that reason, that is why we now ask this court to adopt the self-critical analysis privilege for that precise purpose.
It's an interesting issue. Why should the court do that? The privileges in Nevada are fairly specifically laid out in statute. Why should we adopt this privilege as you've advocated here?
Well, sir, I believe that as set forth in the Southern Railway Company versus Nine case, what really seems to be the inception of this doctrine, even though it wasn't specifically stated within that opinion as it, the Fifth Circuit specifically pointed to the fact that when the railway was investigating a case and submitted a report evaluating the cause, the report, if disclosed, could deter them from seeking full and complete evaluations in the future. And if forced to disclose, it impacts the process of evaluation and prevention of future accidents. And that's our concern here, sir, is that if the opinions are not protected, it creates a chilling force on companies against this particular type of evaluation. And the whole point is that we want people to be safer. We want the world to be made safer as much as it possibly can by anybody, be it a homeowner who finds that there was a problem with the way their child was driving and causes an accident and counsels that child how to drive better, to a manufacturer making a machine. If there is an opinion as to how somebody did something wrong and could do something better to prevent a future accident, a company should not be charged, or anybody should not have that held against them. Because if so, and it's going to be used against them and waved in front of a jury to say, see, they admit it, they admit it, they admit it, and it's basically a chill used in litigation to prevent and almost impel a company against taking such conduct in the future and such remedies.
Okay, any other questions from my colleagues at this point? All right, thank you, Mr. Jaffe.
Thank you very much, Justice.
All right. Morning, Mr. Haight.
Good morning, Justice Harsey, Justice Cherry, Justice Douglas. Donald Haight, appearing on behalf of Real Party Interest, Matthew Burdett. With me at council table is Michael Haight and Eric Willoughby. I think it's necessary to start with a short explanation of what happened in this case. Mr. Burdett was operating a press brake machine. This is a machine that uses a tremendous amount of pressure to bend metal. This particular press brake machine came with a control panel that was mounted on a pedestal, and this pedestal was movable so that it could be moved to various places around the machine to help with feeding the metal into the machine. On the bottom of the pedestal itself, there was a foot pedal. This foot pedal was the only way that a machine was supposed to operate, by pressing or depressing that foot pedal. In this situation, Mr. Burdett had finished aligning the dies. He was in the process of moving the control pedestal when something dropped from the press brake to the floor. He bent over to look and see what had fallen off the table. In doing so, he reached behind him with his left hand to steady himself, and at that point, the press brake came down on his hand and severed 4 fingers. This is not supposed to happen. The only way the press brake is supposed to cycle is if someone depresses the foot pedal. In this case, no one or nothing depressed that foot pedal. What happened was some piece of metal apparently hit the pedestal, or the base of the pedestal, and that caused the machine to go into operation. This was the malfunction. And since May of 2011, when the early case conference was held in this case, Mr. Burdett has been attempting to determine what are the facts and circumstances that led to this malfunction. And since that time, MMI has withheld those documents. At the early case conference, MMI produced the insurance file for MMI. But they claimed a privilege for the report that was prepared by Jimmy Berry and Neil Somerville. They also claimed a privilege for all the videos that were taken of their inspection. These videos are clearly simply related to the facts of the case, but they held that these videos were privileged pursuant to the so-called self-critical analysis privilege. So in this case, there are presently 4 issues before you. One is whether you should recognize a common law privilege of self-critical analysis. That is an issue of law which you hear de novo. The other 3 issues are discovery issues. They are whether the work product privilege applies to this report, whether the attorney-client privilege applies to this report, and then eventually the question is, can Mr. Burdett inquire into the thought processes and conclusions of Jimmy Berry and Neil Somerville?
What if we split the baby in half and allow you to have the facts but not the opinions?
In this case, we think that this is very similar to NRCP 26B4B. In this is a case, these 2 individuals were designated by MMI to go out and inspect this machine. Not only did they inspect the machine, they altered the machine. They, quote, repaired the machine. The machine is no longer in the same manner or the same condition that it was at the time of the accident. Any experts that Mr. Burdett hires would not be able to examine the machine as it was because they don't know what Mr. Somerville and Mr. Berry did to the machine. They couldn't back engineer it to get it back in the old configuration. And so essentially they are at a loss to figure out what condition this machine was in at the time of the accident and at a loss to determine what caused this particular accident. The only way that they can work on that is by looking at the conclusions and the opinions of Mr. Berry and Mr. Somerville. If this case is to proceed to trial and Mr. MMI hires experts, these experts are going to have access to Mr. Somerville's and Mr. Berry's opinions and conclusions. Yet Mr. Burdett's experts, under a ruling that does not uphold the decision by the district court, Mr. Burdett's experts would not have the same access, which creates an unlevel playing field.
Can you obtain the same information through depositions of Jimmy and Neil?
We can do that with the depositions of Jimmy and Neil, but we anticipate that as soon as we ask questions about opinions or conclusions, that there are going to be the same objections raised, and that we will be once again back before this court as to what questions we can ask. The other thing that we're concerned about is that this occurred back on January 7th of 2010, and we think that the written report that was made back contemporaneously with the inspection is going to be more accurate than the memories of these witnesses some 3 or 4 years later.
How are we to deal with the concept of anticipation of litigation as put forth?
I think that what we're dealing with here is the wishy-washy affidavits that were submitted by Mr. Somerville and Mr. Metz. This affidavit basically says, we discussed the accident, we discussed the potential for litigation, and we discussed the potential for the need for an investigation. And these affidavits were put together by defense counsel, and if there had in fact been some direct involvement by Mr. Metz in this action, I think that those affidavits would have said, Mr. Metz told me that I immediately needed to go out and conduct an investigation, that I immediately needed to make a report, that I immediately needed to send it to him and keep it confidential. None of that is in the affidavit, and I think that's because Mr. Metz and Mr. Somerville were not willing to go that far. The best I could say is we had some general discussions about the case. It should also be noted that when Mr. Berry...
Well, wouldn't those comments be protected by the privilege? I mean, if they're having some general discussions with counsel, they can't reveal those specifically. They're privileged, aren't they?
We're not asking for them to reveal those general conversations. What we're asking is that the report itself not be considered work product because it was not done at the specific request of Mr. Metz.
I appreciate the fact that you have focused on what counsel for the defendant knew or didn't know, or instruct or didn't instruct, but when the court's evaluating this, shouldn't the court look at all of the facts, which would include that in this instance, counsel for the plaintiff, unless you dispute this, was present at the facility the day before the engineers arrived? That sounds to me like it's a pretty good indication a lawsuit's coming and somebody better take a look at it, doesn't it?
In actuality, counsel for the plaintiff was there with the insurance adjuster for the workers' compensation carrier for American Metals Fabricators. And he was there in his role as counsel for Mr. Burdett in the workers' compensation case. So, yes, he was there. That may be a pretty good indication that litigation's coming, but essentially the approach that's taken by MMI would totally swallow up discovery, because in today's litigious society, practically anything has the potential for litigation, and practically anything that's being done can be done in anticipation of litigation. And this privilege has to be narrowly construed. In Whitehead 2, the
privilege you're referring to now is the work product?
Work product and also attorney-client. But in Whitehead 2, the court noted that both these privileges are in aggregation of a search for the truth, that they are questionable utility at best, and that they must be narrowly construed. And I think that the decision that was made by Judge Weiss indicates that he reviewed Ballard, he reviewed HCA, and that he felt that by reviewing those cases and then reviewing the affidavits, but that they just did not meet their burden of proof that they had established that either of these privileges apply. Remember that when Jimmy Berry and Neil Somerville came out to see this report, see this machine, they told Ms. Jackson, the safety manager at AMF, that sure, you can have a copy of this report. You know, they were not under the impression that this was going to be a confidential report that was protected by privilege. They just thought they were making an inspection. Additionally, they had already made one inspection in Chicago because they couldn't get their flight out. After they finished at AMF, they went and made another inspection at Absolute Metals, and they told Ms. Jensen that they were going to have to go and make inspections all over the country. So, I mean, this seems to be a routine business process. When there's something wrong with a machine, they go out and inspect it and find out what's wrong with it.
What about the whole issue of it being a risk rather than an appeal in this matter as far as a trial's not been held, correct? No trial. And the word gets out both to the plaintiff's bar and to the defense bar, hey, this Supreme Court's going to hear discovery issues like this. How do you feel about that? I'm going to ask Mr. Jaffe the same thing. I mean, what if the shoe was on the other foot? And every time a ruling's made about the work product or attorney-client privilege, we get it as a Supreme Court on original writs.
Well, I understand that the attorney-client privilege and the attorney-work product privilege are important to all attorneys, and we want to protect those privileges. And I believe that is why this court granted the temporary stay in the first place. But I think that essentially the way to answer that is by upholding the decision of Judge Weiss that we are not going to get into discovery disputes unless there is a clear abuse of discretion. And Judge Weiss did not commit an abuse of discretion. He looked at the evidence, and he was not convinced that an attorney had ordered the investigation, that an attorney had requested the report, and he wasn't even convinced that it was done in anticipation of litigation. This is a factual issue that has to be decided by the trier of fact, who's at the closest level to these facts, and I think that the way to stop writs on discovery issues is to indicate that we are going to leave them to the sound discretion of the trial court. I do want to briefly talk about the self-critical analysis. As far as I'm concerned, NRS 49.015 lists all of the areas where you can have a privilege within the state of Nevada. Self-critical analysis is a common law privilege. It is not allowed in Nevada under 49.015. NMI attempts to make an end run around 49.015 by relying on the DR Partners case, but the DR Partners case is totally inapposite. That case dealt with the public records law, which states that any record is, unless otherwise declared by law to be confidential, is open for discovery by the public. All that the DR Partners case stands for is that the court in that case found a common law privilege of executive deliberations. It was dealing with confidentiality under the open records law. It did not add a new privilege to Chapter 49, and I would note that under NMI's interpretation of this privilege, they have not released any of the videos of their inspection. And these purely are simply factual, showing what took place during the inspection, but their claim of self-critical analysis precludes even release of the facts. So I think that one, it's not provided for in Chapter 49, it's prohibited by 49.015. The legislature should have this matter, should take this matter under consideration, and quite frankly, it's already handled by subsequent remedial measures.
Okay, thank you. Any questions for Mr. Street? All right, thank you very much. Mr. Jaffe?
Let Let me ask you, Mr. Jaffe, the question that I asked Mr. Haight about opening the door to discovery issues. If the shoe was on the other foot and you had prevailed, would you want plaintiff's bar to be able to file original writs in cases like this, always with the claim of work product and attorney-client privilege?
Well, obviously there needs to be some legitimacy to it, and if there is any legitimate threat to the sanctity of the client's right and ability to have their attorney assist them, then there should be an avenue to prevent that at the inception, because no client should ever be placed in fear of not being able to have open communications with their attorney.
Counsel, there's this assertion by the other side that this flat can't get this information, that you're not making any of it available through alternate means, so why isn't this appropriately let in?
That's not true, sir. In fact, we served a privilege law. They filed motions to compel in front of Commissioner Buller. Commissioner Buller made rulings with respect to various issues that they raised, protected some documents, forced others to be turned over, and we turned over what we were ordered to turn over, sir. So,
Did that include the videos?
it's my belief that videos were turned over. I'm not sure. There may have been other videos of which counsel speaks that I'm not sure of, but I believe there were videos exchanged by the parties at one point or another, sir.
Well, consider this hypothetical, since there seems to be, based on the facial expression of Mr. Haight, some doubt about the videos. Does the work product or attorney-client privilege, or if this court were to entertain the self-critical analysis privilege, apply when one of the subject matters of information to be released is the videos of your engineers inspecting the machine and repairing it? This seems to be particularly troublesome in a situation in which the machine has been repaired and experts for the plaintiff are now no longer in a position to evaluate it in its condition when the accident occurred.
Sir, I have an answer for that. It's a lengthy answer. It's going to take me a little past my time.
Go ahead, may I ask the question?
Yes, sir. First off, if there was an issue regarding additional videos, they can ask the Discovery Commissioner to produce those. The Discovery Commissioner freely and routinely will review, issue documents, photographs, videos, whatever it may very well be, in camera to make the determination. If that was asked and it was ordered, we would comply with the order. That's number one. Number two, sir, if the court advises and orders that we are to turn over the document, the fact portion of the document, they're then getting the facts observed by my client, and their experts will be free and able to review those and draw conclusions as need be.
I appreciate your offer of cooperation. I'm talking about the rule of law.
And that's
Mr. Jaffe, what in the privilege, any of those three privileges, protects videos of a site inspection and followed by the repair of the machine, which now alters the product that created this injury?
And, sir, first off, if there's audio on there, then audio could be stated opinions between the people as they're discussing and realizing and concluding what issues may have been. So that is part of it, number one. Number two, sir, there has been...
Is there?
Pardon me?
Is there audio on the video?
Honestly, sir, I don't remember as I sit here. It's been a while since I've reviewed the video.
Okay.
Because I was here for the document, talking about the document, and I don't want to represent to the court something that I cannot truthfully answer. But the other part of it is this, sir. There is no evidence that the machine has been irreparably changed. It is my understanding that the codes from the original manufacturing design are still available and can restore the machine to the condition it was in prior to changes having been made. But here's the problem. They never took depositions. They never deposed Mr. Berry and Mr. Somerville to ask about this. They never deposed Mr. Metz, who arguably put his positions and opinions and statements in the record. They've never asked to do it and proceed to take those depositions to find out those answers. And the problem is that they're now sitting here saying that their experts are hampered when there's no proof for that. There is nothing in the record to support that. And I submit to the court that there is not necessarily any destruction, and it's purely their suspicion and assumption.
Okay, I used up your time on rebuttal. Was there anything else you wish to add, Mr. Jaffe?
Few very brief things. There was a comment with respect to my engineer having said something to April Jackson, who's a representative of American Metal Fabricators. They're not attorneys. Attorneys make decisions as to what privileges apply, not an engineer. Number one. Number two, 49.015 was raised. We believe that this court does have authority. The court said the statute allows interpretation of the Nevada Constitution. The court is empowered, obviously, to interpret the Constitution, and if it deems appropriate to create a privilege or recognize a privilege, just as it did in the DR Partners case. Otherwise, it is to suggest that the justices who issued that opinion were a rogue court issuing an opinion and creating a privilege that it was never empowered to raise. With that, sir, I believe that I've covered all of my issues. We appreciate the opportunity to have argued this before your honors.
Okay, Mr. Jaffe, Mr. Haight, thank you very much for your briefs and your arguments here today. We appreciate them, and the case will stand submitted.